Tell me about a time that you had a pocket memo that helped you out.
Brand new lawyer, Lynn County. They send property disputes to arbitration and support issues. I went to an arbitrator. This attorney was probably a bar number, 25 years old compared to my 1 year old bar number. And we all know you look up the other person's bar number to see how much experience they have. So I knew this person had a lot of experience. So I put the hours in and I was researching, and I finally found just one particular case that talked about if your domestic violence and abuse of a person causes them to have a mental health issue like depression, which reduces their ability to work, that the balance of distribution assets and support can be off balanced, and you can compensate even more for their inability to work. And
you can rebut the presumption of equal contribution.
Exactly. So I found this case. I was there. The lawyer was kicking back in his chair, casual, making arguments. And not only did I embarrass his client who was overvaluing assets, and I came up with this argument and he made an argument and I handed it to the arbitrator and him, and I argued the case, and his face was red. He held his head down because in the end she agreed with what I said.
And he didn't prepare for that.
He didn't prepare. He wasn't ready for some, wet behind the ear lawyer who has no experience, in using some air quotes, right? No experience, that I knew that I had to put more work in to be ready, and I had that in my back pocket. Before I knew what a pocket memo was, that was my pocket memo case to pull out when he argued, you can't do that. She doesn't work. You can't attribute a less wage to her because she could work full time. The presumption is, minimum wage. Well, no, because of your proven abuse, she can't work because she's got a mental health issue now that pretty much has her disabled at the moment. And I just remember the look on the face and the walk of shame, and I felt pretty good knowing it took more hours, but preparation and being ready is so critical. So even as saying earlier, at some point, even young new lawyers can do really good work. It's all about preparation and being ready for all contingencies.
Well, let's break down the failures that lawyer had. So maybe he didn't know the facts as well, that would be an issue. Or maybe, most likely, he didn't issue spot that fact as being important because he didn't know the law, perhaps, or he didn't know the facts or didn't know the law. And that's a lack of preparation. Maybe he rested on his laurels. Maybe the client demanded that he rest on his laurels and not prepare for the case because the budget was limited. Maybe he begged the client to give him a bigger budget. Maybe he really wanted to go do all this research and do these things, right? There can be 100 factors that influence whether or not the attorney gets the job done. But at the end of the day, any man with any sort of dignity is not going to go to trial unprepared, which is why so many lawyers overwork cases that the client can't afford, is because either one, it's fear. They don't want to look stupid. They have imposter syndrome like every young lawyer has. Oh, I got a law degree, but I'm not a trial lawyer, right? So you want to over prepare and you want to be able to have all the answers. And the other side may not want to prepare because either they're lazy or they think they've got it figured out or they've been ordered not to. So you've got to trust that the lawyer is going to be true to their word and work the case and not work the case and not bill you. But how many times has clients told us, no, I don't want that pocket memo? It's like, all right, you want to do it anyway because you want to win and because you have pride in your work. Yes. One problem I've noticed in the last, let's say, 5 years, I don't know if it's the newer generation of lawyers, but they don't seem to care about winning or losing at trial. They don't seem to be ashamed when they get destroyed at trial, where their victim in a case or their client just gets completely destroyed on cross-examination. They're either in denial that it was important and surprised by the victory, which is some sort of incompetence or stupidity or willful ignorance, or they don't care, or most likely they're true believers and they really, really believe their clients or their victim's position, And to me, that's again laziness and incompetence, because if you just ask questions and have time to do it, which like prosecutors don't have time to individualize every case. And so it's our job to individualize every case and go tell them, this is what your investigators missed. This is what didn't get done, and try to convince them to settle it. And if they don't settle it for whatever reason, and for whatever reason is unreasonableness, they don't have a reason other than they don't want to tell somebody no. And why don't they want to tell somebody no? Because they don't want to get canceled. They don't want to get a letter to the editor that this case was dismissed. They don't want to have complaints. They don't want to have bad reviews. Maybe you got to be brave to tell somebody no. You got to be brave to tell the client, this is complete BS. I don't believe it.